Hey, and we're live. Thanks everybody for tuning in tonight. And tonight's topic is the Washington D.C. decision. Thanks to Sean for bringing that to my attention, and also carry in other states, not just concealed carry, but carry in general, because it's part of what happened in D.C. But I want to give everybody a chance for introductions, so I'm going to go left to right as I see them. First up is Edge. Okay, Edge is not there. He's probably getting chewed up by his wife. Now we've got Sean.
Howdy, Sean Carano, the Executive Director of Florida Carry, and run a site at all 9 yards.
Stone Guy 223.
Hey, appreciate you tuning in.
And we got Wesley B80, if I remember correctly.
Yep, I will be playing the part of Yankee Marshall.
Oh, Jesus Christ.
If you don't know who I am, well, turn this off right now because you're in the wrong place. So I'm going to let Sean, since he's the one who knows all about this, take the floor with the D.C. decision.
Okay, so today, in kind of a rare ruling to be issued on a Saturday, a district court judge, federal district court judge, who's actually in New York's, but he sits on the District of Columbia courts. He was hearing the case of a number of D.C. residents and a non-resident of D.C. that travels through the city quite often, on their refusal to issue any kind of a permit to carry. You can't carry in D.C. without a license, either openly or concealed, and they will not issue the licenses.
Now, I'm sorry. I just want to clear. When you say the actual, I guess the district itself will not issue the license, is that who's hindering that process? I mean, is that something like, where a local sheriff won't sign off on the licensing, or is that?
No, in the District of Columbia, everything is run by basically the city councils. They have autonomous lawmaking capability.
Okay.
So you have.
So they're the ones saying. So there's plenty of people that have petitioned or tried to get the licenses, and they're just not going to issue them.
Right, and they don't dispute that we do not issue licenses to carry in D.C.
Right. And so the judge ruled that to be, and you can go. Sorry to interrupt you, but.
No problem. So the judge looked at it. They said, no, we do not issue licenses to carry here. The law doesn't allow you to carry without a license that you cannot get. You also, they won't issue even one of their in-the-home licenses that they have now for anyone who is not a resident of D.C. So say you have a part-time apartment there. If you're not officially a D.C. resident, you can't get a license to even keep a gun in your home there because you have more than one home.
So they say that was unconstitutional for them to keep, or from refusing to issue a license.
Right. So not issuing these licenses is unconstitutional. Therefore, the judge has said that they cannot enforce their ban on carry in the district, and has told them that they must start issuing non-resident license for any of their licenses, including their in-the-home ones. So, as of right now, the District of Columbia is a constitutional carry district. The law is unenforceable. The police have been notified. They know it's now unenforceable. So open and concealed carry without a license is currently legal in the District of Columbia.
Now, how okay, so this one judge declared this to be the case or the law as it is now. how would it be reversed, or like could another judge say I'm overruling that decision, or would it have to be brought to a higher court, or how does that work?
It has to go. It has to go to a higher court. So most assuredly, the District of Columbia will on Monday file a notice of appeal, and it will go to the D.C. Circuit Court, which is they're the Special Court of Appeals for the District of Columbia. It's a co-equal appellate court with any of the other U.S. circuit courts that we have. And they will probably ask for a stay of the decision on Monday while the appeal is pending. I highly doubt that the judge will fail to issue that stay. So on Monday, it's probably all going to go away again until it gets to the appellate court.
Right.
But what this does is it gives us the opportunity to expand the current circuit split that we have. We have the first, second, and third circuits all saying that, well, yeah, there might be some right to bear arms outside the home, but we can restrict that as much as we want to. And then we have the 7th, 9th, 10th, and I forget who else. There's one more circuit that all say that no, you have your right to bear arms outside the home,
right,
and they must either allow for it unlicensed or issue the licenses.
Right.
And there's only so many restrictions you can have on that kind of a license.
Right.
And that's going to be explored more with some other cases.
All right. Well, since this just got ruled on today, I mean, I didn't think that a law or a regulation would go into effect that soon after a judgment came down from the court. I mean, is that just
immediate? It is immediate.
Right.
And what the judge said in his decision was that upon notification, if any of these, if the D.C. police try and enforce these rules upon notification that this decision exists, then they are in deep trouble. Just recently, there was a case in Pennsylvania. It was just decided where someone who was openly carrying was arrested when he was legally openly carrying, and they tried to claim it was disorderly conduct. They tried to claim all this stuff, and that was a $1.4 million decision that just got handed down in Philadelphia. So this
for wrongful arrest or something.
Yes. And for violation of the Second Amendment. It was mostly for that Second Amendment violation, and yeah, a lot of it was punitive in nature. The courts are getting kind of tired of playing this game.
Right. Well, that's reassuring that at least it's going to set some sort of a benchmark for the court system there in D.C. to reevaluate the the status quo before this ruling came down. You know what I mean? It's like, obviously, it's reassuring that one judge, kind of, I don't know, saw the light of day, for lack of a better term, and made that ruling. Because I think a lot of people feel like D.C., it's all crooked politicians that could care less about our rights, and so that's kind of reassuring to see a judge step up and be like, look, this isn't right. This is, I'm changing that. I'm gonna do the right thing here. And
well, in the D.C. circuit, if you remember back to Heller, it was D.C. v. Heller. That's because it was District of Columbia suing Heller to try and overturn what the D.C. circuit had done in saying that they must issue a home license. The D.C. Circuit Court has generally come down on the right side of this for the most part. I won't say that they have completely. There was another case that a lower court judge did there in D.C. It was the Heller 2 case. That one hasn't hit the appellate court yet. that I'm aware of, where they just really didn't rule on this idea of carry outside the home. But in this case, they absolutely did. So it's going to be interesting to see what the D.C. Circuit does. It will further expand the whichever way they go, it'll further expand the circuit split, which is one of the things that the Supreme Court looks at before it takes a case. And one thing that a lot of court watchers believe is that they're looking for a case like this, where you have a state that does not have unlicensed open carry and licensed concealed carry like Texas does, even for just long guns. They don't have any way to carry outside the home except for getting this license that they just won't issue. And a lot of people think in order for Justice Kennedy to really get on board with the Second Amendment case is to have a prevailing party that's on what we consider the right side of the law. Because when a case goes to the Supreme Court, it comes to that court clothed in the presumption of correctness. And the bar that you have to set to overturn a lower court when you get to the Supreme Court is higher than it is to uphold the decision of a lower court. And that's what happened in the Heller case. So the more we widen the split, this is a good case that really had a well-reasoned lower court ruling. I could potentially see this one more than any other contenders that we've had over the past few years being taken up by the U.S. Supreme Court.
All right, because that's D.C. is the place. I think we talked about this in previous chats. So there was, I think it was Marco, Digital Profits, as he's in that area, and he said there was a case of a guy that was traveling from like Virginia into D.C. and just had a shell casing. I don't even think it was a live round. I think it was just a shell casing that was spotted in the vehicle during a traffic stop, and that was illegal, and he was, charged with something for that.
Well, David Gregory from MSNBC was on the video he made. He showed a Magpul magazine, a 30-round magazine, and he was later contacted. That magazine is actually illegal inside the triangle, and but he lawyered up real quick, and the MSNBC got the lawyers involved, and he got given the pass. But even a 30-round mag was letting him stand illegal. But he was trying to make a journalistic, obviously, interview about it, or a topic about it.
A point.
They had to make a point. And,
right.
Yeah, well, and that one, that was just, and there were a lot of people on the Second Amendment side screaming, "Oh, we should charge him if you're charging this veteran who's going to the VA hospital who had a couple of rounds of ammo in his bag. You're charging him, but you're not charging David Gregory, who absolutely had a prohibited magazine. Actually, it wasn't a P mag; it was a steel mag. But and yeah, that kind of rhetoric really doesn't get us anywhere. It's fun to point out the whole unfairness of it all, that a political and news figure like David Gregory gets away with committing a crime while a multi-tour military member is going to a VA hospital because he's a disabled military member and it was still in the military, gets charged, but it really doesn't have a whole lot of basis in the court, because police and prosecutors have always had discretion on what they prosecute and what they don't.
Right. Well, who's a stat? I mean, if to think that DC has such ridiculous rules and restrictions set in place, like I said, it's kind of surprising that a judge ruled in this manner. You know what I'm saying? Like, it seems like with those type of rules in place,
when you have an intellectually honest judge, it's not surprising at all. The Ezell case out of Chicago.
Well, if that's,
the judge
I mean, but
that wrote the opinion on that, Judge Posner, he absolutely hates the McDonald decision. He hates the Heller decision.
right.
He
Well,
does not like this
why
whole
haven't they?
individual Second Amendment, but he ruled the right way because he's an intellectually honest legal scholar.
Well, why hasn't someone petitioned to change these ridiculous laws that would make someone a criminal for having a shell casing in their car? Why do we have to wait until there's some precedent for whether or not they're issuing licenses or not? You see what I'm saying? It's like that. I mean, really, the fact of whether or not you're issued a license should be, second to having these laws on the books that make people criminals for having a damn shell casing in their vehicle.
It's the strategic decision that Second Amendment Foundation, who's been doing a lot of these federal cases, has made to not challenge most of the terms of the licensing and just go after the fact that they're not issuing licenses or they are denying them based on your place of residence. That's then their decision to go that way. We here in Florida made a different strategic decision with our Norman case, and we are challenging restrictive licensing schemes as a whole because, well, let's face it, not everyone can afford to pay for a license. Not everyone can afford to.
Well, not only that, but if
whatever
you're gonna
set of training is required.
If you're going to be pro Second Amendment, you need to be pro Second Amendment all the way around. You don't need to pick and choose. Oh, okay. Well, we're only going to make a legal stand on the licensing, but the other laws, it's okay. You know what I'm saying?
We didn't.
No, not you. I'm not saying you in
general.
general. I'm just saying,
right.
in general that people.
And like I say, we made a different strategic decision to go a little bit more, I guess, fundamentalist when it comes to that here in Florida. But with the SAF, I can't follow their logic. We didn't lose our rights all at one time. It was, the death of 1,000 cuts. We're not going to get them back all at one time. They're putting Band-Aids on those 1,000 cuts. And trying to rebuild
I wanted to talk about this real quick. I don't know if I found this out when I first got my CHL. In Texas, when you apply, you get half. If you're active military, it's free. If you're previous military, it's half off. But if you're indigent, you get the $145 fee. You get a discount if you can prove that you're indigent to get a concealed carry license, concealed handgun license. I was like,
right, and they're a lot more likely to be able to get away with having a licensing scheme where they do things like that, where they make waivers for indigent or make it really cheap for the indigent, where they provide like free, alternative for free training.
Yeah, I know, but it just chaps my ass because okay, there are cheap guns out there you can buy on around $200 price mark, but realistically, if you're that indigent, can you really afford to be out there with a gun? I know it's a double.
Hang on. So you're saying just because you're poor, you don't have the right to defend yourself?
Yeah,
I don't think. I don't know. I think, but I don't think you should get a discount.
I mean, if you haven't been to college and had to eat ramen noodles, you got through pretty well. I've had many times where I couldn't afford to get a concealed carry license, and in fact, after the Army, living here in Florida, there was a time where I could not afford my concealed carry license. I was still in the National Guard. This was after getting off active duty, and I went to my commanding officer, my guard unit, and explained to him that, I usually carry, but I just don't have my concealed carry license right now. So he turns around and issues me orders to be armed at all times. That satisfied Florida law.
It just stings a little more here because I understand some guys it's like $30 or $40, even some places more expensive. But here it's $145 for the fee for the license. So I was like, that's always been like, I don't know, sore spot.
Now, do you think anybody will actually get a license out of this, or are they going to appeal this so fast that none of them get approved?
They're going to appeal this on Monday and immediately ask the judge for a stay of his decision. We'll see if the judge issues the stay. But this judge may very easily say, no, this is a fundamental right, and I'm not issuing a stay in it. And then they're going to have to go to the D.C. Circuit Court and ask them to issue a stay.
Right. Well, then they could just probably issue another judge to hear the case, right?
No.
No. But either way, they've got a clerk sitting outside this guy's office probably already with his tag with him.
Their only recourse now. They have two pieces of recourse. One, they can ask the current judge they can bring him more evidence of why they're right, and ask him to reconsider his decision.
Well, it's not like there's only one judge there. There's more than one judge that could potentially.
No. Lower court case, one judge.
Yep, one.
So their next recourse, if the judge refuses to reconsider, he may or may not issue a stay of his ruling after a motion to reconsider, because what they'll ask for is actually a motion to reconsider or a motion to stay. Now, when you strike down a statute, normally the stay becomes almost automatic when you appeal a case. And I know that is true in Florida state courts and a lot of state courts. I do not believe that the stay is automatic in federal court. That's going to be up to the judge or whoever the administrative judge is for the D.C. Circuit Court of Appeals. So if this judge doesn't issue a stay, they petition the Court of Appeals to hear the case. The Court of Appeals has to hear the case. It's not discretionary on their part. But issuing the stay, if I understand this right, is discretionary on both the lower court judge and the Court of Appeals. But I really, maybe it's the pessimist in me. I do not see this going forward without getting stayed. It's certainly not going to happen before Monday unless they can get an appeals court judge out of bed on a Saturday morning to come in and issue a stay.
Sunday morning.
Or yeah.
I could see them doing that.
And I think the U.S. Supreme Court administrative judge for D.C., I think it might be Elena Kagan or Sotomayor. It's one of the two of them.
Oof.
There is one judge that presides over each Court of Appeals, and they kind of have the final administrative say on a lot of these types of matters. So if it does get in front of Kagan or Sotomayor to decide whether or not to issue the stay, well, I'm sure you can guess what will happen with that.
Cricket.
I do have crickets. I'm in my backyard.
Well, Robbie asked a question 20 minutes ago, and he wants to know, is this happening because D.C. wants to become the 51st state?
No. No, they definitely want a voting member of Congress, but they are certainly not going to be the 51st state. In fact, the Constitution precludes that. You can certainly see Eleanor Holmes Norton, whatever her name is, pitching a fit. There was just a bill that went through basically defunding DC's gun control. Of course, it has no chance of the president signing off on it, and probably no chance of it passing the Senate. But it was a bit of a House of Representatives shot across the bow. And combined with this case, there are liberal heads exploding in D.C. tonight.
If only that was literal.
Oh, they're going to cry bloody murder because some of them have security, and you're going to sit there now. They're a bigger threat. All kinds of crazy shit.
Code Orange.
Well, and I should say there are both liberal heads and statist right-wing heads exploding tonight, because just because you're liberal doesn't mean you're anti-gun, and just because you're so-called conservative doesn't mean you're pro-gun.
Yep.
Yeah, that's what I was going to say. I mean, that's why I think that judge decided away, because the party system's getting old. I know always people are going to vote one way or the other, but it's not helping anybody. It's not helping people get anything they want done. It just, all it does is just divvy it up to where you have all this, are you pro this, are you pro that? And they're like, no, I don't care for any of that shit. That's why what is it, not the independents, but necessarily what they call them, the libertarians are growing. Because people say, I say it all the time, I'm not really hardcore conservative, but I'm definitely not liberal, and I'm kind of stuck in the middle. All I care about is, the things I think that are important to me, and it seems like all that stuff's being pushed to the wayside because everybody's always trying to get that freaking money from the lobbyists, and therefore, your voice is muted by money.
Yeah, one of our board members is Rob Allen. He runs a blog at Sharp as Marble. I think he says something about too liberal to be conservative, too conservative to be a liberal, and too smart to be a libertarian.
Yeah, I'm the same way. I mean, classify, I tend to vote Republican in elections because they tend to have more of the values I agree with, but I don't agree with everything that they have, and it's hard finding somebody to vote for that has most of the stuff I want. I mean, sometimes there's a Democrat that heaven forbid, but sometimes a Democrat that has more issues I'm interested in.
I don't think it's a lost cause, because I never thought Eric Cantor would get thrown out. That dude was like hardcore, like really sewn in there. Him and Mitch McConnell, as far as decision makings and the RNC, and really tugging, the party line and everything. And I never saw Eric Cantor, because that dude is like, he's always had that really aggressive attitude about stuff, and they tossed his ass, man.
Yeah, no, it's horrible.
Well, I've never found a politician I've been totally in love with, and probably won't until I run for public office, which isn't likely.
You mean you're not all for Chris Christie?
Hey, I'm digging Scott Walker.
Scott Walker, yep. I'd vote for him.
I figured Sean would be all in love with Debbie Wasserman.
Oh, man.
Get a piece of that.
Oof.
I'm one of these weird people that believes in legalizing marijuana, even though I don't touch the stuff. Believes in pro-choice, because it's not my damn body. And both of those things are...
I would totally be a libertarian, except for I think they have some very weird opinions on foreign policy and our projection of military force.
Dude, I was a big Rand Paul, or not Ron Paul. I was like, he's dead on. He's like, who's that old coot that had all that money, the Texas guy? What was his name?
Ross Perot.
Ross Perot,
and I was one of the idiots that voted for him, and thanks to idiots like me, we wound up with Bill Clinton instead.
Thank you very much for your support.
But Ron Paul, man, I was like, they went into the debate. He's like, how the hell are we going to pay for all this? Who's going to do it? And they're like, everybody looks at them like, hey, shut up. We need airtime in the debates. We don't need you just squawking there. You're not going to get elected anyway. His son, I don't agree with. I think his son's a little on the. I don't know if he's trying to make a name for himself. He already has, and sustain that. I've seen some things he said. I think, statements of it that I did for. Okay, well, that kind of makes some sense. But for the majority of the time, I don't agree with Rand Paul very much at all. Which is not. I just don't like his thing. I don't like his mindset. His daddy, I can deal with them.
So let's kind of get this back on topic here. Let's talk about Well, I'm looking at concealedcarry.us, or excuse me, usacarry.com. There we go. I'm thinking of the handgunlaw.us. Sorry. I really thought there were a lot more may issue states. You know, I'm talking about states. I won't go into the territories, but you know, may issue to residents only is only California, Delaware, New York City.
Well, define it for people listening that aren't familiar with those terms, may and shall.
All right. Shall issue is that if you fill out all your paperwork and send everything that you do and take that class and everything, and as long as you got a clean criminal background, you're going to get a carry no matter what. They will issue that. May issue is they decide if you're a carrier or not. It's not up to you.
Right. Yeah. In shall issue, there's no discretion on the part of any bureaucrat. If you meet the terms of licensure, you get the license. With a may issue, well, depends on the particular bureaucrat reviewing your application if they're going to grant it or not. And in a lot of those places like New York, you have to show good and substantial cause. And just self-defense they don't consider enough cause. Now, if you are, say, an actor and you say you want it for self-defense, well, you're famous, therefore there's probably more people out to get you, so we're going to give you one. But your neighbor who's not famous isn't going to get one.
Yeah, unless he's got a restraining order or something weird going on, and that they're actually getting a good bureaucrat.
Right, and even then, you have to show that the restraining order, the person after you, is substantially likely to, kill you.
Hawaii is on that list too, aren't they?
Right, I'm talking about. I was just reading the
Hawaii was
interrupted me, politely interrupted me.
Yeah, well, Hawaii was, but they're in the Ninth Circuit. The Ninth Circuit just ruled that may issue violates the Constitution. Hawaii's in the Ninth Circuit. There's a current case going right now. It just referenced Peruta. It looks like Hawaii is going to have to start issuing a license.
Well, that's good.
Yeah. And there are may issues to residents and non-residents. That includes Connecticut, Maryland, Massachusetts, New Jersey, and all of New York State, not just New York City.
Yeah. I always just call those a may not issue.
Yeah, they may not. Well, it's will not issue. That's what it really comes down to. It's kind of like.
It's eerily quiet in here.
I think Cork got kicked out. Someone corked Cork in his own court.
I thought I got kicked out for a second.
Just muted.
He corked himself.
It's a baby.
I know, like in certain counties in upstate New York, it's all about the judge, and I think the judges are elected, so depends which judge is in power in your county and stuff, because I've talked to people that were like, oh, this judge is really cool, it's a may issue, but this one judge is pretty much like shall issue, it just depends on who you get, which is horrible.
Well, Hosh was talking about that in Northern California, where it's a little bit more gun-friendly. And very cool luck.
Thank you. Got a bunch of stuff I finished today.
Nice.
Let me tell you, Huck, before you tell me yes, why are you going to send it to me for free?
Yeah.
We'll save that for the knife chat that he needs to start.
Yep.
I think we're doing that Monday, right?
The money clip.
Yep, there's another one.
All right, well. What up?
Now, what's going to be interesting, I think, to see, who was that guy who's all associated with Code Pink and all that stuff, who open carried a shotgun in D.C. here a few months ago and caused all that?
Oh,
Adam Kokesh.
Yeah.
Now,
that you disappeared off the map, didn't he?
Yeah.
He's probably in
given
jail.
this latest court decision out of D.C. saying that their ban is and has always been unconstitutional, it's going to be interesting to see what happens with cases like his. And I'm not talking about just him. I'm talking about anybody who has recently been arrested for.
Well, that doesn't matter. You can't.
In the district.
That a new ruling doesn't vindicate.
No. You're confusing that with legislative enactments. That's ex post facto rule on legislative actions, basically laws. What we're saying, what's happening here is you have a law that has been ruled to be unconstitutional. That means it's always been unconstitutional.
Yeah, but that you can't go back. That no
you actually,
court system in the
yes,
world
you can.
go back.
Yes, you can. You're confusing this with later legislative enactments. Court rulings are retroactive.
No, you bring me you show me a court case where they ruled and they went back and retracted or
show me a cop that's become a lawyer.
vilified, any cases where that was the case.
I've seen some police play lawyers.
Hang on, my lawyer's calling. Maybe he can tell me.
Dun, dun, dun.
Well, there you go.
See, now you did it.
Ask him, 'cause seriously, you can't just because they ruled on whatever. Previous cases aren't subject to that new ruling. You can't go back and find someone innocent after you've deemed whatever law unconstitutional. It does not happen.
I'm not a lawyer.
The law was unconstitutional. It has no right to stand.
But yeah, it makes sense. It's retroactive.
Yeah, it's retroactive because you were.
What the fuck you're talking about? It's not retro. Like I said, show me some case law.
Pull out the cop book you're talking about right now. You look at it.
All right.
Well, Stone Guy, you're wrong there because if it's unconstitutional to begin with, the law has always been null and void.
Can I bring up something? Because I'm so quick-witted.
What the fuck?
So she ruled that the D.C., them not giving out carry permits is unconstitutional. So whoever's sitting in jail right now for not having a registered gun no one is sitting in jail in D.C. for not having a permit. You understand? So there's no one who can go, I'm in jail because of something was ruled unconstitutional. Because you were in jail for something else. You're in jail for having an unregistered gun,
shot that guy, man,
being caught without a permit or whatever, because I'm sure it's two different charges. If they were just recently, after G.C. Heller, letting you have a handgun. So who's sitting in jail in D.C. because they didn't get their permit in time or something like that? Nobody.
I'm not a lawyer, but if it's unconstitutional, it's always been unconstitutional, so the law has never been standing.
Yeah, like I said, it's unconstitutional that they're not...
That people are charged with every fucking day? What are you talking about, the laws notwithstanding?
The law, it's unconstitutional that they do not have a carry permit. So how is that... How is anyone sitting in jail going to win on appeal?
Well, as I said, I'm not a lawyer, so you need a lawyer to be able to justify it. But if all of a sudden they took away your First Amendment rights and you started getting arrested for it, and they found out that you were being arrested for your First Amendment rights, and because of a stupid law this state enacted. You would be taken out of jail because of it. You'd have your sentences commuted, or
I believe DB. I heard DB's hanging out Dan Bilzerian, dude. He's hanging out with the Blizz now.
I mean, Court, where you are, didn't they just start giving out permits, or was it the state of Illinois? Just now they're forced to give out permits. That doesn't mean if you're sitting in jail for having an unregistered.
Okay, guys. So. I'm actually speaking to our attorney, Eric Friday, right now. In Chicago when the Illinois Supreme Court ruled on the Aguilar case, which ruled their concealed carry licensing scheme unconstitutional. Immediately, the city of Chicago had to release from prison, I think it was, or from jail, hundreds of people. These things are absolutely applied retroactively when a statute like
Quick to your face on that.
Now, get your lawyer on here. These are people that may be pending charges. That's
or
different.
Still on appeal, or
exactly.
or still running through the system.
Different. Exactly,
they
it's
get let
completely
out.
different. You just confirm what I've been saying. If someone's already been charged and convicted,
and anyone who's been convicted in the past year can get rehearing, which will mean that.
So now there's all these variables, and that's what I was saying. There's if you've already been charged and convicted, I didn't know the year grace period, if you will, but that's what I'm saying. It's not like they're going to take someone's criminal record from 5 years ago when this law gets passed and wipe it clean because they reevaluated the law and changed the ruling.
Yeah. It only goes back so far. Once the case is up and complete, nobody has, and you've lost your ability to appeal or have it reheard, then you're pretty much stuck like Chuck, no matter how wrong the law that you were convicted of was. But typically that winds up with a lot of sentences being commuted, though.
I have a question for Sean. So, if you're sitting in jail in Chicago, what were they getting released on? Because aren't the charges you were caught with an unregistered firearm, like possession of an unregistered firearm, or?
No. The charge there, and the judge specifically said that you cannot enforce these provisions of law, which is having an unregistered gun, carrying a gun without a license. He laid out 3 or 4 different DC laws that are now unenforceable.
Okay.
So anybody that got arrested, is awaiting trial, in the middle of a trial, awaiting charges, those people, unless they stay this whole thing, which may very well happen, they're getting a get out of jail free card.
Like in DC, they have registration, and they have registration in Virginia, and they have registration in New York. But my whole point is that if you have a gun that was registered, and you got caught carrying that gun without a carry permit, then I can see it's common sense that you might have to be let out now, because it was unconstitutional. They should have been able to give you a carry permit, or you should have had the right to at least apply. But if you were caught with a stolen firearm and you bought it off the street,
and charge.
And you had an unregistered firearm, forget about it. Man.
If you were a felon in possession of a firearm, all that still applies. It's just it's one less charge on those people.
Right.
Now, in Illinois, if you were caught carrying with...
What are you over there talking shit about, Edge?
So now I can't call my cousin and tell him the good news. I was all sucked up. We can do all kinds of shit over there now.
In Illinois, you need this
mumbling over there.
card, which is to be able to buy a firearm and be in possession of a firearm, you have to have your FOID card. So if you're arrested and you didn't have a FOID card and you had the firearm, then it's going to still stick because you didn't have your FOID card. If you had your FOID card, then you would have been let out.
That's different than my Pourquoi card.
All right.
Hang on, I think we're going to be able to get Eric on here. Give me 1 second. I need to send him the link.
Oh, cool.
Oh, definitely send Eric a link. I'm more than happy to have him on here.
Who's Eric?
That lawyer that we had on the other
lawyer, yeah.
Okay.
Not the kind of lawyers you used to, like, dude, this is cool.
No, I was going to make some jokes, but I'm
Oh,
sure.
did you guys see that one video that Jaeger put out with that guy giving the crazy hot scale?
Yeah, she's a dude.
That was his lawyer.
That was the funniest shit I've seen all month on YouTube.
So that dude was cool as shit too, and he was like, "Yeah, it was my attorney." I was like, "Damn, that's awesome." You have that kind of, down to earth attorney that you can cut up with and willing to get on camera and make that kind of video. That was funny as shit.
It's crazy because I remember when he did a video about getting back his carry permit. It was the same guy, but he was like a totally different personality. You remember that video?
Oh yeah, well yeah, because that was
that was him.
They were skating the line there. He was like on thin ice trying to.
It's the only time I've seen Jaeger in a suit online.
Well, I do have something interesting because in Wisconsin we have this city called Milwaukee, which has a population right around 1 million people, and the police chief went on a little rant.
Can folks hear me?
Yeah,
we got you, Eric. What's going on, brother?
Oh, just out giving the dog a walk.
I hear you.
I've been doing honeydews all day, so I have not read any of these decisions. I haven't read Dots versus Flocks, our Florida case, nor have I read the Palmer decision.
Yeah, Eric, I'll give the cliff notes. They ruled on the difference between the right to keep and the right to bear arms. The right to bear arms being outside the home, the right to keep being inside the home, and therefore their failure to issue any concealed carry license to either DC residents or non-residents both are unconstitutional under the Second Amendment. That won't withstand any level of scrutiny.
Now, was this the DC district judge, or was this the DC Court of Appeals?
Yeah, DC district.
Oh, you can expect me. I would tell you that you can probably expect the DC Circuit Court of Appeals to issue an injunction staying the decision either tomorrow or Monday.
Yeah, as of tonight, they're constitutional carry, but that will all probably change tomorrow or Monday.
Wow. Now, how long do these usually, they put a stay on this and then it has to be heard by the next court up, correct?
Well, what they'll do is they'll put a stay on it. Usually the stay will be for, let's say, 30 days, the 30 days for the right to appeal. And if the appeal is filed, then they'll stay it indefinitely until an opinion is issued. So what that means is you can expect that the extensions for filing of briefs in this case. I'm sure the city will ask for a myriad of extensions, but I don't think they'll get them. The court won't go that far, probably.
Can they request an en banc hearing?
Well, they haven't even had an initial hearing yet, but they will probably get the initial 3 judges and then an en banc if they don't go. If it doesn't go whoever's way.
Yeah, at the current level, there's only one judge.
Oh, okay. I misunderstood how far it was.
And I wouldn't expect this to have a whole lot of precedential value throughout the country until the Court of Appeals rules on it. But it would be very odd. Most circuits will not overturn or rule contra to the DC Circuit Court of Appeals.
Well, what other district or state or city had a no issue? They're the only one, right?
Well, I don't know what the practicalities of Chicago's has been yet.
The last was the last no issue was Illinois.
Right.
I don't know.
Denied. Yeah, the right denied are the District of Columbia, America Samoa, and North Mariana Islands, or Mariana Islands.
Their decision applies to all the territories too, which probably Puerto Rico as well.
Puerto Rico's in the first, sir.
Yeah, they are may issue.
Oh, Puerto Rico is not considered part of the DC Circuit?
Somebody got a rattlesnake?
I cut out there for a second. Yeah.
No, Eric's out walking his dog.
I'm out walking. If I'm bugging y'all too much, I'll turn it off. But
is that a bird? Or
he's getting attacked by a tree finch or something.
Crickets or something.
I got crickets in my neighborhood like you would not believe, and it's 90-something degrees here, and they are going crazy. Excuse me, it's only 87 right now at 11 o'clock at night.
Maybe it's a dolphin.
Yeah, so when this is heard by the appeals court, and if it's upheld by the appeals court, then this will affect the May issue states?
No, only certain states that are considered in that same district.
Right. There's no states in the D.C. circuit, but they control the federal enclaves. Like Puerto Rico is actually in the first circuit.
Hawaii's part of that too, isn't it?
I think
Hawaii's ninth.
No, Hawaii and I believe Samoa is also in the Ninth Circuit.
Yeah, so is Guam. The American Virgin Islands.
Yeah.
Virgin Islands is in the Ninth? Okay.
No.
I guess I worded my question wrong, but will this have any kind of legal precedence for other states that have May issue? Will it helps the people that are fighting for shall issue in those states? Was what I'm getting at.
Not until the Court of Appeals rules on it.
Right, and if they uphold the decision, then it's a good thing for them.
Yeah, if they uphold the decision, if the D.C. Circuit Court of Appeals upholds the decision, you can expect to see a lot of interesting rulings out of the other circuits because they don't normally go against D.C. Circuit likely.
Yeah, and I'm going to call it right now. This may very well be the right to bear arms case that gets to the Supreme Court.
I mean, for one thing, it's one thing to rule against the Ninth because everybody jokes about the Ninth. They don't just overrule the D.C. Circuit in other circuit courts. You know, it's one of those some pigs are more equal than others kind of deal.
That is, I'm sure hoping it gets upheld because that's going to be awesome.
Yeah. Decision because it is in my slightly less than lay opinion one of the better reasoned ones I've read.
Yeah, that's the way it sounded. So I'm looking at these May issue states. I'm like, that'd be so awesome if they also became shall issue states.
Well, and what the court didn't rule on, they didn't rule on what the restrictions can be. They just said that you cannot fail to issue a license when someone says, I want a license to carry outside the home for lawful self-defense, which makes it essentially a shall issue.
Yep.
But what they didn't rule on is what fees can be required or what training requirements there can be or any of those additional ancillary issues to the issuance of the license. And it's because, you know, those issues weren't brought up. They were trying to keep a very clean, very simple case. We're going to get a decision on this one issue. If they come back and say that you'd have to have a $3,000 license, then there'll be other cases to deal with that.
Yeah, because I'm thinking, you know, like Illinois, that's, you know, $150 license and 16 hours of class time and range time.
Right. I'm going to Illinois here in a couple of months for a Gun Rights Policy Conference. And because of their licensing scheme, I mean, for an out-of-state license, it is $300, plus I would have to take a 2-day class. There is no way I'm going to take a 2-day class and spend $300 to get a license to carry in a state that I'm going to be in for 2.5 days.
The only difference between in-state and out-of-state is the 150 versus the 300. The training requirements are identical.
Yeah. Oh, and I've got good news for Dano here since we're talking about Illinois. Wisconsin now accepts Illinois permits.
Yeah, they've for about a month and a half now, I think.
Yep.
And so does I think Utah or Nevada, I think. Their county sheriffs had their annual meeting or whatever.
Yeah. Well, we talk about this. I want to stress this because it's very important. Know the laws if you're going to be visiting a state, just in either carrying or just being in a possession of a firearm, because you don't want to end up in hot water and possibly losing your Second Amendment rights and a whole bunch of other rights too because you made a silly mistake. And also, that you don't want to end up like, what's that person that got arrested because they were driving through? I can't remember his name, but
very simple. Never assume you have reciprocity.
You never assume, and then you got to know not only your state laws, but the state you're visiting laws, because they could be different. So there you go. Now we got Eric back. I'll open the floor if anybody's got questions for Eric. Okay, well, if we're going to have this dead air, I'm going to end up shutting this chat down.
Well, let's bring up the other topics you wanted to talk about tonight.
That's it. I just wanted, because I knew we would talk about the D.C. decision for quite a while. That was the main thing, and I just wanted to make sure that, how this could affect other states.
Well, while we're talking lawsuits, we did just have a decision here in Florida. It's the Dox v. Glocks law, and this was of the 11th Circuit Court of Appeals that upheld our law here that was previously struck down by a federal court judge. And this one prohibits doctors from requiring patients to answer questions about whether or not they own guns and predicating service on whether or not you own a gun. So we had a problem with healthcare providers actually saying, if you have a gun in your house, if you own a gun, I will not treat you. I will not treat your children. We won't provide you home health care services. And the 11th Circuit Court of Appeals said that, yes, that law is completely valid. We have long regulated physicians and said what they can and cannot do. This is a valid exercise of the police power of the state to regulate this professional conduct of physicians, and upheld our law saying that doctors can't screw with you for being gun owners.
Hey Eric, what's your take on this? We kind of had a chat the other night about the influence that insurance companies are having on big corporations and companies that don't allow their employees to carry firearms. So what's your take on this doctor that was able to stop a shooter and the potential backlash that he's facing?
First of all, what state was that in? Somebody was asking about this today, and I wasn't even sure what state it was in.
Pennsylvania.
Okay. Well, first of all, we just passed a bill here in Florida this session that prohibits insurance companies from discriminating against gun owners. So, for example, an insurance company can't deny you insurance because you are a gun owner. And we actually had an example where somebody had been denied homeowners insurance because they tried to schedule their firearms as additional valuable property. And not only did they not let them do that, they canceled their entire policy. So that's the problem that we were having and that we just solved partly. But look, the states that have gone open carry, like my most example I'm most knowledgeable about is Alabama, because I'm also licensed to practice there, and I'm from there. And they've had constitutional open carry and shall issue since the 1800s. But they passed a statutory bill last year, or 2 years ago, and now every sheriff in the state has gone around and had no gun signs printed and posted on every door. Now, the no gun signs do not have any weight of law to somebody open or concealed carrying with a permit, but they do have weight of law if you do not have a permit. And regardless of them not having weight of law, people are being told to leave the business if they're open carrying. So the primary driving force behind that, other than the sheriffs, is insurance companies saying, if you carry here, or if you allow people to carry in your restaurant, or you allow employees to carry, we're not going to cover you anymore. The only way that we're going to fix that problem is by statutory changes in every legislature, and that is a change that, for example, punishes businesses that don't allow carry and holds them strictly liable for criminal acts on their property. Right now, if you're attacked going into a Walmart, for example, and Walmart's one of those companies that actually is very gun friendly in terms of they've got a corporate policy of not prohibiting any lawful carry in their stores, whether it's open or concealed. But right now, if you're attacked in the Walmart parking lot, at least in Florida, I, the attorney, have to show that in order to sue Walmart for failure to provide adequate security, I have to show that Walmart knew or should have known that they had a crime problem in this particular Walmart parking lot.
Right.
And one of the things we've advocated for is a rule that would impose strict liability if you ban guns from your premises, but also additional legal protections from suit if you allow guns.
That'd be cool, because I was going to ask a very similar question.
And what we're talking about there is an affirmative allowance. We mean the green circle with a gun in the middle, carry okay here.
Well, that's the thing we talked about the other night, was the fact that, to me, I would, if the insurance companies weren't so scared of the potential liability associated with an employee using a firearm for protection or to stop whatever the situation is and accidentally wounding someone, an innocent bystander, if the insurance companies would get behind that person and say, look, not only, tell the corporation or the grocery store or whoever, say, look, we're going to stand behind you. We're going to allow your employees to carry. And if by chance there is a situation and an innocent person is injured in the commission of stopping an active shooter or, some atrocity, that we're going to stand behind you. We're going to protect you, and we're going to be on your side. But right now, the tendency, the default, is to just ban it, to restrict it.
Eric, would you talk about the doctrine of transferred intent and how that applies to third parties being injured during a necessary self-defense?
I guess not.
Hold on. I was trying to unmute. I was trying to keep it on mute because of the bugs. All right. There's a common law doctrine called transferred intent. It's one of those funny things they teach you first year of law school. And that is, if I, for example, battery is an intentional crime, I have to be intending to hit the person. Well, when I intend to hit A but hit B instead, well, I didn't intend to hit B. No, but you intended to throw a punch. So it doesn't matter whether you intended to hit A or B, and who you actually hit doesn't matter. If you intended to hit somebody and you hit somebody, the intent follows your fist in that example. Well, intent also follows a bullet. Now, I don't know about every other state, but in Florida, we have transferred intent both for justified and non-justified homicides. So if I have a legal right to shoot somebody, and oops, I screw up and shoot the wrong person, I'm aiming at A, who's attacking me, and I accidentally hit B, who's just an innocent bystander, the intent follows the bullet, and the person responsible to Mr. B is Mr. A, not me. Now, the problem comes in if transferred intent may or may not protect you if you are reckless in your bad shot, that's, you may not have protection. But if you were merely negligent, well, actually, even if you're reckless, the criminally will not attach, because criminal liability will not attach because of lack of intent, lack of bad intent. Civil liability might still attach, but you won't have to worry about criminal. And civil probably will not attach unless you have reckless conduct in your firing of the gun.
Right. So if I shoot Mr. Bad Guy, who is a clear threat and it is a justifiable shoot, the bullet goes through Mr. Bad Guy and hits someone who was unknown to me behind him and kills the person behind him, but only wounds Mr. Bad Guy. Mr. Bad Guy is going to jail for the murder of the person that was standing behind him.
Even if it's an accomplice, in fact. If a police officer shoots one of two bad guys involved in the commission of a crime, the surviving bad guy is convicted of felony murder.
That old man out in California that shot that woman that was pregnant, the man that was with her is being charged with that.
Absolutely.
That's a good example of that.
Absolutely. That's the when two folks conspire to commit a crime like that and one of them ends up dying, you can pretty much guarantee that one's going to be charged with the other's murder, even if they were shot by a cop or an innocent citizen.
Yep. And I also read today somewhere, I wish I could find it, but I read that hospital was not going to do anything to that doctor, like fire him or any kind of actions toward him for carrying in that hospital.
Well, we have a really interesting situation here in Florida that's starting to be litigated.
I wish I could have found it. I'd have posted it, but I looked for it and can't find it.
Our guns in parking lot statute that we passed back in 2005, it's the issues now coming up as to whether it might protect a business employee who has to shoot in the protection of his property, of his employer.
Now, Eric, did you get to see that interview the news did with that guy that shot that woman in California?
No, I have not. I've been a little bit non-news for the past few days. We've had a couple of big hearings Thursday and Friday, and so that kind of just kept me out of the news cycle.
Oh, okay. I was gonna, if you had seen it, I was gonna kind of use that as example of what not to say after a shooting, because he said some stuff that made me raise an eyebrow, and I'm just
Eric will tell you after a shooting, don't say anything other than "I want my lawyer."
Well, the guy that could comment those kind of comments that they make. One of the most egregious ones, I think, was there was a guy, I think it was Texas a couple of years ago. He was on 911 telling the operator, if this guy comes out of my neighbor's house with my neighbor's
dead air, Court. Come on, keep it going.
Don't talk to the cops. Don't be an asshole toward the cops, but
don't say bad things to 911 either.
Yep, and Eric is talking, that's okay, so you were quite late on that.
Huh?
He is?
Guys, I'm going to drop off.
Talking, dude? We've been sitting here for like 2 minutes with no one saying a word, and you're not running. You didn't say anything.
I'm going to
get on the ball.
I'm going to drop off and get on my computer now that I'm back. Hold on. I'll be right back with you.
Yeah, Stone Guy, for some reason, couldn't hear Eric, but Eric was talking. I could hear him loud and clear.
I can't hear him either.
Yeah, I can hear him.
Yeah, he's going to drop off for a minute and get back on his computer with an actual microphone. When I called him earlier, he was out walking his dog and was kind enough to jump in.
Can't believe Girk started another chat.
Oh, B. Girk?
He probably wants to talk about TC and how he's going to be carrying for tonight or something like that.
Yeah, I'm going to carry for the next 48 hours straight.
Yeah, but I found that interview quite interesting. If you haven't seen it, go look it up, because
Well, the problem is that if that thing was just released, the decision was just put out today, it's going to be hard to inform a whole precinct of officers.
Oh, no, it's not. Shift change briefs, man.
Yeah, dude.
They never read those. They just go crackheads. They don't care.
But believe me, they are more than aware of this one.
Yeah, because
Well, hopefully they don't go out and accidentally shoot somebody tonight because they have a gun.
Well, and you know, look, if somebody's got a gun in their hand and they're out there brandishing and being reckless with one, then yeah, that's
something they shouldn't be doing.
No. Legal or not.
Well, you shouldn't just be walking around with a gun in your hand.
No, no, I don't think so.
What are they saying?
That would not fly in Illinois.
Yeah, it's either in a holster or you're at home.
Right. Yeah. If somebody's out there brandishing, got a gun in their hand, yeah, they're in deep doo-doo and liable to be shot, and that's fine, and liable to be arrested for all kinds of things. But if somebody walks down Pennsylvania Avenue with a gun in a holster tonight, it's completely legal.
Yeah.
Guys, can y'all hear me now?
Much better.
Yeah.
Hey.
First time I've ever been happy to hear a lawyer talk.
See, I always found lawyers helpful.
Somebody actually invited me to come talk to a group Monday night, and I'm sitting there thinking, and somebody asked me if it was a charge to come see me, and I'm sitting here thinking, would you actually pay for it? I mean,
donations are welcome.
I understand why somebody who's in trouble comes in and pays to hear me talk, but unless you're already in trouble, I'm not sure it's worth listening to. But
Eric, I'm going to send you a stack of Florida Carry membership forms to hand out.
I've already got back. I got the brochures. We got that covered. So, guys, while y'all are talking, I'm gonna pull this decision up on my other screen and start taking a look at it, because like I said, I'm clueless. I only know what Sean told me on the phone a few minutes ago.
Okie dokie. But to fill the space here, there was a shooting this week again in Milwaukee. We call it Little Chicago. Two kids were hurt in a minivan from the shooting. Again, I think it was two thugs exchanging fire. But the police chief came out and went on this rant about how the state government isn't doing enough to stop these criminals from doing it, and not penalizing these criminals enough. And he went on about saying that because you got to conceal carry and you're carrying a firearm, or if you're just carrying a firearm without a concealed carry, and again, but concealed carry, all you're going to get slapped with is a misdemeanor charge. But the problem that Milwaukee's having, and this is my take on this, the problem Milwaukee's having is that these are already criminals. They've already been through the system, and they're already felons. So they're already getting a charge for having a firearm.
Well, shouldn't they already be charged with what they actually pulled them over for, or what they actually did to create a legal search of their body?
Exactly. Well, a lot of times, whatever they were searched for ends up not constituting a crime, because remember, all you need is reasonable suspicion that a crime might have been committed. And believe me, it's pretty easy for a cop to make up reasonable suspicion. We see it all the time. So,
some guy's famous for it.
All right, let's. I mean, come on. Be a douchebag.
But I love this. This is one of these things that this police chief of Milwaukee said. You know, we've got just about 1 million people. He gave the exact number. And we've taken 600 and some odd guns off the street this year. Where New York City, 10 times our size, only took off the street 200 and some guns. I mean, how can you do that comparison? It's one of those weird things that it doesn't make sense. You've taken 600 and some guns off the street in Milwaukee, and I know some of those 600 and some guns were because a woman who was a legal concealed carrier accidentally left her gun in the bathroom in a place where it was legal to carry. They confiscated the gun, so they count that as, a firearm right there.
Well, it also assumes that per capita the number is the same, even though the populations are diametrically opposed.
Yeah.
I mean, if even though New York City is multiple times bigger, if per capita, and of course I have no idea what the numbers are, but let's say, just for the sake of argument, they're significantly lower, the amount of illegal guns. I don't believe that's true, but I'm just saying, for the sake of the argument, it could. Well,
they almost 700 guns taken off the street in Milwaukee, according to the police chief. It's only 200 and some taken off the streets of New York this year so far.
It would skew the statistical results, and that's why a partial statistic that.
We actually saw a case where they were saying, oh yeah, we took this many guns off the street. And what they didn't say was, and we found out later, was that they were counting the guns that they got at their gun quote-unquote buyback.
That's what I'm thinking that they're doing here in Milwaukee too, is a gun buyback.
Have y'all ever attended a gun buyback?
No.
I want to. With a couple $1,000s.
Well, here in Florida, we've started in certain counties where there's no legal impediments. We've started having members of ours and followers show up and attempt to purchase guns from people coming in. Cops have done everything they can to shut it down, but and by doing things like having police officers on the public dime at a private event on private property that nobody else is allowed to, and even the press is not allowed to attend. They've actually kicked members of the press off of the property. But we've seen the guns coming in, and some of them, in one case, I saw a guy bring in 2 barrels with a trigger guard attached, and that was considered those were considered 2 firearms that he got $50 each for.
Yeah, that's what kills me is how much they're paying for these things that are like.
Remember the guy that had the empty law rocket tube?
Oh my God! Really?
Yeah, I saw that one.
Those are worth about $100 if you were to buy one on, from a surplus store or something.
That one was in California, wasn't it?
There was one in California. That was the one that got the most press. We've actually seen a few incidents of things like that. There was somebody that brought in a dummy grenade. I mean, totally the ones that you see mounted on a piece of wood with a complaint department, take your number sign on it, and them going crazy because, oh my God, someone brought a grenade.
They pay them for it?
Oh yes, they paid them for the dummy grenade that you can pick up at your your local military surplus store.
Didn't somebody bring in a flamethrower as well?
The gunbacks that I've seen in my area always remind me more of a marketing plan than an actual plan to do something. What are you slapping there?
Well, somebody said flamethrower a second ago. It's interesting. In most states, it's completely legal to carry a flamethrower.
Yeah, there's a lawyer here in town who has one.
Yeah, look, what I want to do is I just want to go to a gun buyback and bring my BB pistol and see if they'll actually take it, because it looks like a pistol. I've had this thing since the 80s, I think.
Eric, I can imagine which lawyer you're talking about, and if he has one, we're going to have to all go to the range.
Actually, he's not one you know, Sean.
Still, range day.
We need to get him out there. He says.
I was going to say, if I don't know him, you have failed in your duties to introduce me to the right people.
Well, he doesn't really get out and do anything for gun rights. He's more of a criminal. He does criminal defense and PI work, but he doesn't really get out and take an activist stand. He's a collector.
I don't care. He's got a flamethrower. I want to go fire it. So make it happen.
It's a Russian when there's some part he needs that he's never wanted to get. You can get it, but he's never wanted to get it. He's scared of the ATF considering it to be a firearm all of a sudden if he gets whatever part this is.
Interesting.
So I'm trying.
Just because they're lawyers don't mean that they know the law.
Yep.
He's called me and asked questions before, so.
One of our other lawyers likes to say that, well, every time you walk into court, at least half the lawyers in the room are wrong.
Help me, guys. I'm out of questions because he actually answered the one big one I was going to ask.
Well, I'm about page 9 of 19, so I'm getting there.
Is 19 pages short for a ruling or long?
Something like this. Well, normally a district court ruling, 19 pages is probably about normal. For this case, I'm shocked it's this short.
Wow.
Yeah, and it's kind of amazing that as much ground as he does cover in such a short opinion. It's well cited, it's well reasoned. He doesn't mince words too much.
It's a great opinion so far. I'm impressed.
Wow, nobody's willing to help. All right, come on. Anybody?
And of course, I was really happy to see him affirm what I was saying the other day about this difference between the right to keep arms and the right to bear arms, because it's starting to become a pet peeve of mine. It's almost like when people call clips magazines, and magazines clips. It's not the right to keep and bear arms. It is the rights to keep and to bear arms.
Wait, all you did was pause.
No, the rights, plural.
Oh, the rights. Okay.
You have two specific related rights. One is to keep arms, which means having one in your home, to have a possessory interest, to own one. The other is to bear, which is to carry, and specifically to carry in case of confrontation.
For sure.
Hey guys, I mean, we all know it's been every opinion that's come out since Heller and McDonald that the anti-gun side has hammered on that little sentence from Heller of the right is not unlimited, for nothing in this opinion should call into question long-standing prohibitions on. And I keep wondering, exactly what do they mean by long-standing, because hell, the ban on schools came from the late 90s. The ban
well,
on...
they had just gotten through analyzing the meaning of the Second Amendment in the 18th century. I'm thinking they were thinking very long-standing.
Well, you would think so, but every court that's ruled on it since then has, and even in that decision, they said schools. Well, hell, the whole schools and government buildings prohibitions didn't come into vogue until the 60s to 90s time frame. At one point, many states required you to carry a gun to vote or required you to carry a gun to church. So, yeah, I don't know where they get that. But I was just in a hearing on Thursday, and my gosh, the lawyer couldn't get to that sentence quick enough on the other side. It was like one of the first things out of his mouth are, Florida Carry is citing Heller, but Heller says this.
Yeah, and Eric, when you're done reading through this with all the interruptions that we're giving you. But you're pretty good at multitasking. If you just give them a quick update on what that case was about and where we're at.
Sure.
Was that the having a gun in a dorm room at college?
Yep.
Nice.
I got a question here. This is from CWP 1863. Yes, what's going to happen to Shireen Allen in New Jersey? Are you familiar with that case?
Yeah, this could have an impact on that case.
Okay.
Yeah, it's again, a lot of where this case goes is going to depend on, or how much impact this case has is going to depend on the appellate court. What you will see is you'll see people like Allen and any other cases like hers around the country are going to be doing everything they can to stall their cases to give the D.C. Circuit Court of Appeals a chance to rule on this one, because whatever that, I mean, look, I've got a couple of cases I might even try to stall based on this. I mean, this is huge.
Yeah, it definitely seems that way. It's good news all around.
There, I dropped off for a second. Where was I?
Well, every time you leave and come back, you get quieter and quieter every single time.
Really?
Yep. Okay. Every time I have to turn you up just a little bit more when you come back.
Okay.
Yeah, the first time it was like little 2 clicks up, and now we're up to 6 clicks up.
It's Apple messing with me.
Steve Jobs, you bastard.
He's coming after me from the grave.
This judge is, I mean, he's relying so heavily on Peruta. I mean, I think that's interesting. He really focused on Peruta. I didn't see if he focused much on Moore and Madigan. But he said something about Kachowski too. But hold on,
he did that where Moore v. Madigan was talking about Peruta. He also cites Ezell.
Yeah, I noticed Ezell was in there.
Yeah, but yeah, he was really following the Peruta logic, which Peruta, they got it right.
Yeah, and I'm familiar with what you are, but those that aren't, could you explain?
Peruta was the California case about their May issue policies with I believe it was the San Diego Sheriff's Department or San Francisco, one of the two. But regardless, the sheriff was just not issuing licenses unless you were one of the special people.
Ooh.
And the Ninth Circuit said, no, you have a right to bear arms outside the home. California no longer allows for open carry without a license, and they don't allow for concealed carry without a license. Therefore, you must issue licenses. Now, that case has been kind of going back and forth right now with who's going to be the intervening party in California. The California Attorney General is trying to kind of take over the case from the sheriff. The sheriff is not opposed to the California Attorney General doing so.
You saw the
they're trying to appeal it to the U.S. Supreme Court. It'll be interesting to see where that one goes, but as of right now, that decision is good law in the Ninth Circuit, which is going to affect California and Hawaii.
Y'all saw that the Brady campaign got shut down on their request to file an amicus in one of the cases out there. Was that Peruta or something else?
I think it was Peruta, but I'm not positive.
All right. Well, I got a question here from Robbie, and he asks, are things beginning to turn around in our favor?
I think they've been turning around in our favor for a long time. The toughest thing about where we are right now, it takes 4 votes to get anything heard by the Supreme Court. So at least 4 judges have to say, yeah, we're going to hear this before the Supreme Court takes a case. And they only take somewhere in the neighborhood of 100 a year. Now, the supposition, and this is getting into deep analysis beyond my knowledge or abilities, but based on what other commentators like Eugene Volokh and other people like him have said, is that whole line about the right is not unlimited, nothing should cast, well, and nobody would ever contend, I don't think the right is unlimited, but the addition of that line that nothing should be taken to cast doubt on long-standing prohibitions, the general consensus of the experts seems to be that that line was put in to satisfy Kennedy. Because what happens is, when the court's looking at these, all the justices have their law clerks, and when I say law clerks, these are typically lawyers that have practiced several years, and when I say practice, they've worked for other federal judges in the lower appellate courts before they get hired by the Supreme Court. And they're all almost exclusively from either Harvard, Yale, Columbia, Berkeley, there may be one other one. But you can kind of get the idea of the kind of people you're getting.
Georgetown.
Huh? Oh, Georgetown. I mean, we're talking about, for the most part, people that have never lived in an environment where crime was a reality. People who've never wondered where a meal was coming from, for sure. Yeah, definitely a upper tier of our socioeconomic groups. But anyway, these law clerks draft basically memos and sections of these opinions, and then they're circulated among the judges, and messages go back and forth, and all of this, of course, is highly confidential, and nobody knows exactly what anybody says, but the general supposition is that that line was put in there specifically at Kennedy's request, or at least to get Kennedy on board. And I don't think any of the, I don't even want to call them pro-gun because I'm not sure how pro-gun they are. I don't think any of the pro-gun justices are confident enough where Kennedy will come down on any particular case to take another one. I think they were okay with Heller, they were okay with McDonald after his concurrence in Heller, but I don't know what it's going to take to make them feel comfortable. And you know, this gets into
and there's some supposition out there that the Abramski case was a little bit of a bellwether on where he was going to come down on some of this stuff, and Abramski, he was the swing. He was the one that said that no, I'm not buying it, and just because everybody that was involved is believing that this guy didn't commit a crime. So that boded very badly for us.
Okay, so...
Well, this is sort of off topic there, but what do you think the chances of one of the justices leaving in the next 2 years is? Well, I guess I should say that there's going to be another appointment.
You're going to see, I think we have a very high likelihood that Ginsburg will be retiring.
So at least one?
Well, I think you're going to see one or more of the liberal justices will probably, most likely Ginsburg, probably will retire in time to give Obama a chance to nominate somebody else. But yeah, I would say that you're not going to see anything better. I mean, good God, I think, and this ought to scare the hell out of you. I think Ginsburg is a more intellectually honest jurist than either Kagan or Sotomayor.
Yeah.
Now, she may be an ideologue, she may have a bent, but I think she is more intellectually honest about her rulings than either Kagan or Sotomayor. I don't remember Ginsburg particularly lying to Congress like Sotomayor and Kagan did.
Amazing how they get away with stuff. Yeah, and, sadly, always a possibility that one of the judges could pass away too, and there's always a chance. Mostly they're old, so.
I pray for the health of Clarence Thomas every time I go to sleep.
Mm-hmm.
Because we're dealing with Clinton-era judges have been in there the longest. I don't think we have anybody left from Reagan. Or Bush. No, not Reagan. Bush Sr.
No, I don't believe there's anybody left from him.
Well, Reagan was Kennedy. That was after Robert Bork got borked by Congress. Remember, we had a Republican president and a Democrat-controlled House and Senate. During the Senate confirmation hearings, Robert Bork, who was seen as too conservative for the liberal Senate at the time, just absolutely got railroaded. And that's why we wound up with Kennedy, who was seen as much more middle of the road and, has been the swing vote. Kennedy's going to go the way that Kennedy goes, and it's hard to read him.
Hey, Sean, I'm curious. What did you think about the equal protection part of the DC's opinion?
I thought that I read it and I said, okay, I owe Eric an apology.
What about?
Because I told you I'm not buying the equal protection angle on some of this stuff, but when they start talking about especially when they started talking about the right to travel issue, now they didn't get to that. They basically, but
what I thought was interesting was what the judge's comment was that on that issue, and what the judge said basically was, well, yeah, I understand the equal protection argument, but guys, they're not treating residents and non-residents any differently. It's not like they're giving permits to residents and not to non-residents. The law says they're giving permits to residents, but not to non-residents.
Yeah, but what I found interesting is while he didn't get into the equal protection, other than saying, well, there's no equal protection area here, he still said that you must issue to non-residents.
And that could be really interesting. We may end up with a situation where every state, like Illinois, like California, like whoever else,
Florida,
that doesn't like, but Florida already issues to just about anybody.
Yeah, and Illinois is a shell issue.
We do, but it gets back to this idea of what can they do with reciprocity.
Well, I don't.
Florida will issue to anybody who's otherwise qualified, no matter where they live, except for what if you're an expat? What if you're an American citizen that lives and works full-time overseas? You cannot get a Florida concealed carry license, and we won't recognize an out-of-state license if you can get one there. So, say you're a U.S. citizen who lives in Germany because you work for a defense contractor. And you can't get a Florida concealed carry license because you live in Germany. And you get say a Utah concealed carry license. Well, Florida won't recognize it because you're not a resident of the state of Utah either. So I think that's where the interesting equal protection argument comes into play in a case like ours, where we have a generally pro-gun state that issues licenses generally fairly, but there are some issues like this.
By the way, if y'all didn't know, George Zimmerman has appealed his the dismissal of his defamation suit against NBC.
Interesting.
Now, is that case out of New York or is that a Florida case?
The Zimmerman?
Yeah.
It's a Florida case sitting in front of it was in front of the same judge that did the criminal trial, because she's generally a civil judge. In Florida,
he's going to have probably a lot more luck in the 11th Circuit than he would in.
No! It's going to the 5th DCA.
It's a state court.
It's a state court case. He's got the same judge for that case as he had for his criminal case.
Oh, okay. I didn't realize that.
He filed a defamation suit. That's a state law action.
Oh, gotcha. I thought he sued. Well, actually, I thought it was a libel case.
Yeah. Probably gonna be defamation and libel.
Yeah, 5th DCA here in Florida is kind of a weird court of appeals. You can just never quite tell which side they're going to come down on.
They include Orlando, so one of the more metropolitan cities in Florida, but they're based out of Daytona, which, because when they created these courts in 68, 69, it was before they had heard of Disney World in Orlando. And so they placed it in Daytona because it was the biggest city in the area at the time. But it also includes a place called Ocala, which is in a place called Putnam County, and it is about as rural as Florida gets.
Yeah, in Ocala, the men are men and the sheep are scared.
Yeah, it's Hickville, but it's it's backwoods. It got some.
Well, I don't know if I'd call it Hickville, but I will say that it is where one of our most pro-gun state legislators is from, and he's definitely responsible. Well, he's one of the legislators responsible for Florida's stand your ground law.
Well, when I said that, I'm speaking more of the more rural areas of Putnam County, and there are some backwoods parts of Putnam. I mean, there's just are, but it's also known for being a huge horse training ground for the well-to-do. It's a nice place to train horses in the winter when everybody else is freezing their off. All right, but analysis on the DC opinion. He spends 90% of his time identifying exactly who the plaintiffs are and why they've got an action. So he spends a good bit of time on that.
Notice he did not shoot down SAS standing.
No, I think it'd be pretty tough to shoot down SAS standing in a case like this. And anyway, they've got more than enough individual plaintiffs to not worry. They usually don't start shooting down organizational standing as long as you have plenty of individual plaintiffs. And it looks like they put together a nice little collection here. He really focuses. I mean, he addresses, I think, just about every major appellate decision that's come down in the past 4 years since Heller and McDonald. I mean, he deals with Ezell out of the 7th Circuit, Kachalski, which was a really crappy case out of the 2nd Circuit. He deals with Moore v. Madigan out of the 7th Circuit. He deals with Peruta out of the 9th Circuit. I'm kind of surprised he didn't get into Bonaty at all, which is a case out of the District of Colorado. It's a district court case, not an appellate court case, but it was a very...
Bonaty was just a district court case, and it was a little bit more tangential.
Anyway, but the principles are still there. Sean, help me out here. Was Peruta the one that went through the analysis of we're not even going to look at decisions like Kachalski because they're not really relevant because they disregarded the history set that's already been established by the Supremes?
I think that was Ezell.
No, it's not Ezell.
Oh no, they looked at it and they just disregarded it because
Peruta really looked at it. Said, okay, we've got basically 3 categories of cases that other other appellate or district courts have done. We've got cases that absolutely take the history of McDonald and Heller, and those cases that accept the history of Heller and McDonald set forth, those we have to give more precedence to because they're based on the same reasoning as Heller and McDonald.
Yeah, you're right. That was Peruta.
Whether they're good or bad, pro-gun or anti-gun, they at least accept the history. Then you've got opinions like Kachalski that pretend to accept the history as set forth by the Supremes, and to the extent that they accept the history and rule consistent with what the Supremes have said, we might give those a little weight. And then there's some other decisions, and I forget what their example was, but decisions that basically give the finger to the Supreme Court and completely ignore what the Supreme Court has told us to do, and we don't give those any weight at all because the Supreme Court's already told us what to do, and we're not going to disregard the Supreme Court. And for that reason, Peruta, of any of the cases to come out since McDonald, Peruta is probably the most extensively reasoned, and I think they even did one better than Moore v. Madigan. I think the Peruta court was very thorough in their opinion, and their opinion is used heavily, very heavily throughout this one. In fact, there's one section where he basically takes a paragraph from Peruta, switches District of Columbia for everywhere Peruta said San Diego, and says, what's the difference? There is none. The Ninth Circuit got it dead on. I'm not going to mess with it.
And it's important to mention that these judges in the Ninth Circuit that ruled on Peruta, these were not pro-Second Amendment people, and it was a 2-to-1 decision there. Then the same 3-judge panel that ruled on Peruta, even the dissenter in Peruta, when they went to the Hawaii case, all 3 of them unanimously said we're following Peruta, and Hawaii's no-issue licensing or may-issue licensing is invalid. So even the Peruta dissent said, well, it's settled law, I got beat there, and ruled the right way on Hawaii. So that's impressive when you have a judge willing to say, yeah, I was on the wrong side of this, I don't like it, but I'm bound by what the other 2 people in this same case said.
And I'd have to say, despite the jokes about the Ninth Circuit, look, the 11th Circuit is generally a fairly conservative circuit, but you give them a Fourth Amendment case, I can tell you right now, they're going to be a pro-government decision, regardless of what it should be.
Yeah, well, the 5th and the 11th lately.
Yeah, you give them they are what I would call conservative but statist judges. The Ninth Circuit's interesting, despite their liberal reputation. I don't know if the liberalism is well deserved as much as I find the Ninth Circuit very often, along with Posner and Easterbrook out of the 7th Circuit, to be very intellectually honest. The 11th the 9th definitely has a liberal bent to it, but it's a very intellectually honest liberal bent, and a little bit, it can tend to be even a little libertarian in the Ninth Circuit, which is the far and away an exception in any of the other circuit courts of appeal. They definitely have a more libertarian bent than anybody, and I think that's probably why they went along with the way they did in Peruta, was because of a libertarian bent rather than necessarily a conservative or liberal bent. But getting back to the D.C. case, the judge spends a lot of time looking at Heller, looking at McDonald, looking at Moore v. Madigan, looking at Peruta. I think Peruta more than anything, and just keeps coming back to the Supreme Court's already said that there's a right here, and it's a right to keep arms, it's a right to keep and a right to bear arms, And the only reason they haven't addressed the right to bear arms before is it hasn't really been before them because it wasn't really addressed in Heller and McDonald. But it was looked at a little bit more by the 7th Circuit, and it was looked at in Peruta by the 9th, and at the end of the day, there's no way to justify a complete ban, even if just because you create a licensing scheme. If you're not actually issuing the licenses, you don't have you don't have a leg to stand on. You're denying the right. Now,
Eric, obviously you're not licensed in D.C., but in your personal opinion, am I right? Or is D.C. now a constitutional, at least for the night until they stay this thing? Are they a constitutional carry district?
What I haven't looked at, I haven't seen the exact one. The order says that there's 2 statutes that no longer apply.
I pulled the statute. It is their statute that says it's illegal to carry.
Okay, so one of them looks like one of them's their licensing statute, right?
One is the one that says that you cannot carry a handgun without a license to carry.
Okay.
The other is their licensing statute that says we don't issue under unless you're a resident, and we don't issue for any reason other than having a gun inside your home.
He didn't put any kind of stay in here.
There's no stay.
Also, the other interesting thing, this is a senior judge. So you've got your appointed judges. They're appointed for life. Well, when they retire, which happens much more commonly in the district court than it does in the Court of Appeals or the Supremes, but when they retire, they're given the option to take something called senior status, and that basically means they come in and cover for retired for judges that are on vacation, or judges that are taking a leave of absence or sabbatical, or there's a vacancy waiting because Senate won't approve whoever the president wants, that kind of thing. So this is one of those senior judges. I don't know anything about this name. The name doesn't ring a bell with me. The judge in Bonity, for example, the Colorado case, he's actually the senior. He's a senior judge, but he's actually the judge that tried Timothy McVeigh. But if they've said no enforcing the statute that bans carry in the District of Columbia, then yeah, that makes them constitutional carry for the time being. What I would expect to see is you're probably going to see the D.C. Police Department suddenly issue a few permits over the next 24 to 48 hours. I can see D.C. issuing some permits in the next 24 to 48 hours and using that to go back to the judge and ask for a stay on the grounds that, look, Judge, we started issuing permits now. Will you please reenact our ban? We're going to issue one to each of these people that are in this case, so they'll be covered. Will you please reinstitute the ban till we can get some? Will you please issue a stay otherwise till we can get something done? If the U.S. Attorney for D.C. and Kathy Lanier, who is probably too much of an ideologue to have any damn common sense about the issue, if she had any common sense, she'd issue those permits for each one of these plaintiffs immediately and ask the judge to stay the decision in general, since she's now issued the permits.
Eric, I do have a question. Because I remember this ruling, I think it was earlier this year, about possessing a firearm in the parking lot of the post office.
That's that's the Bonity case.
Okay.
That case only applies to that post office at issue. And in that case, you can at least, I don't remember the details of the decision, but you can certainly leave one in your car in the parking lot of that post office for sure.
Well, and it was also an as-applied challenge for a person who lives in a rural route and does not have his own mailbox and is forced to go to the post office to get his mail.
It's a very limited, but it's a very well-reasoned decision that has a lot of capacity to be used elsewhere, but it doesn't have a whole lot of impact or precedential value for the time being. The post offices are one of those places where I'd say, from a legal standpoint, I think you got to be crazy to either have one in your car on the post office property, or to carry in the parking lot, or to walk inside to your post office box with it. I mean, from a legal standpoint, I just don't think there's any way you can get away with it just yet.
Yeah, which is
the interesting thing about that is as far as some of the when you talk about some of the gun rights organizations, it is the first good thing that I've been able to count that Dudley Brown and the National Association for Gun Rights has ever done, and it is that limited.
You know, this is what I don't get about that law. You have, you know, at least here in Wisconsin, we have the Castle Doctrine, where that extends to your vehicle, but it doesn't extend to your vehicle if you're in the parking lot in your vehicle and at a post office.
Well, you know, that case extends to Mr. Bonity and anyone like him who has no alternative but to go to the post office to get their mail at that particular post office. Yeah, I mean, there were some great dicta in that case where, you know, where they said where the judge reasoned that a lot of really good things and took the next logical step on some good things that we really need. The judge got it right, but the problem is it was a very limited question. It was a very limited circumstance, and it's a very limited ruling that the post office was smart about. They didn't appeal it, which means that it has very limited impact. If they had appealed it and then gone to the Court of Appeals, it would have had much wider impact, and in fact would have made it a lot easier to apply nationwide. Since it's just in that one post office is applied to that one person who's in this one very narrow circumstance because he lives somewhere where he can't have a mailbox at the end of the street, it doesn't have a ton of value, but it's you know, it's helpful, but not something that's really a game changer.
Okay, that's good to know. I'm going to end this chat. We're almost at 2 hours here, so I think it's a good time to stop it here for tonight.
There is one thing. Does that law apply if your post office isn't posted? Because my post office doesn't have the "Don't Carry in Here" sticker on the door.
It doesn't matter.
Yeah, it doesn't matter. Yeah. Posting doesn't matter. It's considered a federal facility, and federal buildings are prohibited places. You know, and this is a problem for people that, you know, say you go to a national park and you want to use the bathroom. Arguably, the bathroom is a federal facility. Literally, the facilities are a facility, and therefore you can carry in the national park, but you cannot carry into the bathroom.
Yeah, I wonder how this plays. You really got to go to the bathroom, but you're carrying. Is it okay to go to the bathroom out in nature then and not go into the building because you really had to go? You can get a, you know,
I don't know. Eric, would that be an argument of necessity to use the necessary?
He said be right back, so.
I'm back. I was able to hear. You know, that's an interesting question. I don't think you can argue the defense of necessity, but it's a problem. Look, I mean, I just
Well,
spent.
I didn't think you could either, but once again, my version is funnier.
I just spent a couple of weeks hiking along the AT, and basically all of the shelters, by definition, can be called federal facilities, even though every one of them is built entirely by volunteer effort and volunteer funds. They're because they're on a national scenic trail. Arguably, they're a federal facility, and I had to stop occasionally in federally established, maintained restroom facilities that were.
But that raises an interesting point. At Denali, don't you, or was it Yukon or Denali? One of the two, you have to carry a gun.
Denali, if you go into the backcountry of Denali, you're required to carry a gun. But as far as I know, the backcountry of Denali has no federal structures.
But are there any structures which would arguably be federal structures?
In Denali, I'm sure there are, but the thing is you're only required to have a gun in Denali if you're in the backcountry.
Yeah, well, as I said before, we're going on 2 hours. I want to thank Eric and Sean. Great information. It was very well taken and much appreciated. And everybody,
give us a couple of weeks to see where this thing goes, and we'll jump back on in a week or two when we know more about where this thing's going.
Yeah, that would definitely be awesome.
Second week of August, Florida Carry is starting our little Monday evening chats. We're going to do it every other week. So I think they're going to be Monday at 9 or Monday at 10. I'm waiting to hear back from G-Webs exactly what time we're going to do this. And well, Eric, we got to coordinate on times. But yeah, second week, second week of August, we'll start those every other week.
Yeah, well,
and it's all going to be about really Florida stuff, but we'll of course delve into the federal issues as they pop up.
Yeah, if you want to tap into the gun channels crowd, they're kind of used to everything starting 10 Eastern. For the most part, at least that's my knowledge.
Don't kill me now.
I know.
Well,
I know.
I think Stone Guys is at 10, so we might come on earlier.
Yeah. Yeah, I was gonna say, and if you're gonna do the 9 Eastern, you just want to make sure you get the word out on gun channels that you're doing it at 9 Eastern or 8 Eastern, whatever time it is. Just get more people aware that you're doing it. Definitely bring it up in these chats.
Mm-hmm.
So thanks everybody, and good night.